evening, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. It's Tuesday night. That means we are doing our Tuesday night live program. Thanks for joining us. Now, everybody knows the rules. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and you can always check us out on any of your favorite podcasting apps. Now, we've got a lot to talk about this evening. We got the Letecia Stauch case. A lot of people have been asking questions about that, as to how that case possibly got reversed in its entirety. Let's remember the Letecia Stauch who killed her stepson, 11-year-old Cannon Stout. Not good. The Tanner Corner trial is going on down in Texas. Gerhard Cody case is going as well. It's just about done. The sentencing of the Oakland security guard case. And guess what? The Gilgo Beach family, a son of one of the Gilgo Beach victims, filed a lawsuit against the family members against Rex Heuermann, who's supposed to plead guilty tomorrow in New York over there, and apparently suing the family for the $1 million that they received for the documentary. Interesting theory. We'll have to check that out. Now, before we get started, we didn't do it today because it arrived while we were filming this morning, but we got our battle box. So what is a better time to do the battle box than do it live? So let's do it quickly. For those who don't know, this is not a paid promotion. It's something I ordered a long time ago. I have more stuff now than I could possibly ever use. But when the great apocalypse hits, we'll do that. Now, since we're live, I can't use my K-bar. And unlike Brian Koberger, I did not lose my K-bar. Remember, Brian Koberger lost his. I've had this since the summer of 1988, the year I went to Marine Corps boot camp. So we've got it. But I can't let you see it. Otherwise, they'll demonetize us because, well, that's what they do. You can't have weapons on live TV, if you can imagine that, which is absolutely silly. But that's what they do. Because I think they think that somebody could think that I could be trying to hurt myself when I'm not. Why would I be doing that when I'm opening my battle box? So put this away, keep it in a safe spot so we don't lose it. First thing in the battle box, let's take a look and see. Where's our little instruction book here? Did I not get a little instruction book today? Oh, no. Oh, no. No instruction book. Okay. Let's open this. This is some sort of escape thing. I'm not really sure what that is. But I'll have to go look online because I don't see my little book of telling me what to do. But apparently some sort of, according to the package, some little escape thing. That's interesting. Let's see this, some sort of pouch of carrying case of some type. Let's see if it's of any specialty here. Comes with something. No, just looks like another small pouch. It's kind of a small box. Usually they're packed full to the tilt. Just a little bag, I guess you can put your little thing to get you out of trouble there. Let's see. A knife. An Atlas knife. Let's see if we can do this without getting demonetized as well. Little knife flips open. See if it's sharp. Yep, it's sharp. Kind of like that. So that's a knife there. Good to go. What is this? Some sort of micro tool. 8 tools in one. Keychain ready. TSA compliant. Lifetime warranty. We've got a lanyard, a bottle opener, a pry scraper, a wrench for various sizes from 5 millimeter up to 9 millimeter and 3/16 up to 11/32, and a flat screwdriver. Oh, looks like we got another knife, a flipper knife of some type here. Huh, that's weird that we got 2 knives. Usually we don't get 2 knives in our set here. Okay, look at this. This is the knife. Nice enough. Let's see. Take a look. Oh, pops right open. There you go. Put it away. You don't want people to get too scared looking at that. And the final item here, this is, I don't know, I'm not going to lie. This is, usually they're a little more interesting. I'm a little disappointed. Well, let's see. Another backpack. Just what I need. Another backpack. Okay. I guess it's nice. There it is. Another backpack. So there's the battle box for today, for this month. Usually they're, frankly, I hate to say it, they're a little more exciting. This one is a little small, kind of a little lame, but that's all right. You never know what you're going to get. It's like Christmas Day when you open the battle box. All right, so let's move on. Enough of that nonsense before we get to start talking about a couple of things. I think first we need to talk about is Letecia Stauch. But also remember, ladies and gentlemen, go check out the link below. Get your Crime Talk gear. Get your merch, man. We had somebody I knew came to the office, started talking with somebody and said, hey, I watched this guy. He was like, I know this guy. I ended up giving him some merch to give to that particular person. Now, I can't give away merchandise to everybody, but if you come to CrimeCon and you come check us out, meet us, then you can do that. You can do that. We're going to have all kinds of free giveaways, and we're going to be in the, what do we call it, Annika? The Creator Studio. Is that right? Creator Row. So Frank will be there. Annika will be there. I'll be there. The lovely Miss Kristen will be there for a little bit of time. She's got to tend to a family matter, like a graduation of some type, but the show must go on, ladies and gentlemen. And gosh, when is that? Next month? Next month, end of next month. So now's the time. Make your plans in Las Vegas. I get nothing out of it, but you can come see us. All right. And we'll give you some free cool stuff. Excuse me. All right. So let's get to it. Letecia Stauch. All right. We brought you this trial when it was originally being aired down in Colorado Springs before they had silly rules that you can't live stream these matters. And so for those who don't know, Letecia Stauch, convicted by a jury of her peers of murder, child abuse, bad things to a corpse, you name it. So what happened? Well, the facts came out at trial. She killed her 11-year-old son, Gannon Stauch, for some bizarre reason. It was something silly. But she gets upset. She kills him in the basement of the house. Blunt force trauma, I believe, to the head. And ultimately, she wraps up some carpet, hides it. The dad was actually in the military and was deployed at the time down in Colorado Springs. And there's a big Army base down there called Fort Carson Army Base. And dad didn't know anything about it, right? So what does Letecia Stauch do? Well, first she tries to dispose of the body. She plants it up in some area north of Colorado Springs, kind of in the hills. Then she goes and retrieves the body at some point and then transports it with her daughter, unbeknownst to her, when they're having this U-Haul truck, and they dump Gannon Stauch's body on an underpass down in Florida. They find Gannon's body some 4 months later. In the meantime, they don't have enough evidence to arrest Letecia Stauch. She goes, I think, home to, I think it was Myrtle Beach, South Carolina, if I recall correctly. Ultimately, she gets arrested. She gets extradited back. While she's being transported across country, she literally tries to escape from the jail. I believe it was in Wichita, Kansas. They get her back to Colorado. She tries to escape from the detention facility here in there in El Paso County as well. And she's just not, clearly things are just spiraling down for her, and they only get worse. There's a bunch of delays in the trial proceedings. Ultimately, they go and tries to go with some sort of, what's the word I'm looking for? Almost like she goes NGRI, okay? She pled not guilty by reason of insanity. Remember, not guilty by reason of insanity is basically an affirmative defense. saying that you did it, but you had a reason, or in this particular case, she suffered from dissociative identity disorder. But needless to say, the jury rejected that and found her guilty. The trial sentenced her to life in prison without the possibility of parole, plus 2 consecutive sentences for tampering with evidence. Anyway, goes up on appeal. Stauch claims the court committed structural error when it denied her challenge for cause to a biased prospective juror when they deliberated. Now, this is where it gets interesting. All right. There's been 2 thoughts of this in different rules, but Colorado changed the rules a while back. All right. So let me give you an example. You have a juror, and in this particular case, you have a juror who is in a relationship within the 3rd degree by blood, adoption, or marriage to a defendant or to any attorney of record or attorney engaged in the trial of this case. So in this particular case, there was somebody that I believe was their son-in-law, worked at the district attorney's office, worked as a DA in that particular office. Should have been excused. Boom, just like that. Okay. Just like when you say, hey, there's certain qualifications, like here in Colorado, they ask if you ever been on a bond of anybody. Do you know the people? You ever sued them? They've been sued by you. And do you work in law enforcement? If you are a law enforcement officer, currently employed, off the jury you go. Are you employed by the public defender's office? Off you go. Okay. That's it. You work for the Department of Corrections. Boom, you're out of the jury pool. So in this particular case, there's a clear statute that says you have to get rid of this particular juror. But what did the prosecutor do? What did the judge do? They said, well, really, he seems like a nice person here. Let's keep the person on, right? Anyway, the judge denied the defense challenge for cause. A challenge for cause is that, the statutory challenge for cause. Judge, you can't have this person here. It's in the statute. Okay. Clear as day. All right. And the prosecutor objects. Well, Judge, what do we really know about this person? I mean, really, he's a son-in-law, works at the DA's office, but does that really matter? And I mean, come on, Judge. And the judge is like, well, you're right. That's okay. Defense objects. They say, okay, fine. So this is where it gets a little tricky. There's 2 rules that you used to have to do, right? So if you had a challenge for cause that the judge kept off the jury, you'd have to use your peremptory challenge. And normally in a homicide case here in the state of Colorado, you get 6 peremptory challenges plus 1 more for each alternate on the panel. So I think they said 2. So they got 8 peremptory challenges. The defense used all of their peremptory challenges. Peremptory challenges, you can get rid of anybody for anything unless you're the government. And if you try to get rid of somebody based upon their race, religion, sex, sexual orientation, like, oh, Judge, they're getting rid of all black females. Let the record reflect my client is, black male. They're getting rid of all the black, jurors. It's called a Batson challenge. And the judge will say, well, do you have a neutral thing? Well, Your Honor, I didn't like one of the answers of the particular individuals, and I didn't like it. And judges say, well, that's okay. And then you have to raise the issue on appeal if you lose for a Batson challenge. Okay. But like I said, so challenge for cause is denied. Then you get your peremptory challenges. That's where we'd like to thank and excuse juror number 6. They go away. And then they go back to the prosecution, and you go back and forth. And you have to say, Judge, I'm using my peremptory challenge on juror number 6. I'm making that number up. Because you denied my challenge for cause, and therefore I'm getting rid of them, but I would have used my challenge for cause on this other juror, but since you deny my challenge for cause for doing it. Well, Colorado changed the rule a while back and basically said that you don't have to use your peremptory challenge to get rid of the bad juror, because if you've got an unfair trial, you got an unfair trial. And so the court, denying that, said, okay, fine, judge, you want to deny my challenge for cause? We're going to keep this juror here on the panel, and we're going to keep it as an appellate issue. And guess what? That is what the defense won upon, because the juror was originally an alternate. If he'd been an alternate or remained an alternate, never would have been an issue. But the juror deliberated, and guess what? They say that is structural error. And, and I hate to say it, but we talked about this a little bit last time we talked about this. This is what prosecutors and judges do. Like, for the love of God, Your Honor, we've got 85 other jurors. Why do you want to create an appellate issue by keeping this one juror on, other than the prosecutor just wants to say that they're right? Like I told you, when I was a prosecutor, your job is not only to do justice, but your job is to protect the record so that there is not error, which results in an unfair trial, which results in a reversal, which results in a do-over. Okay? Now, don't get me wrong. Do I think Letecia Stauch will more than likely be convicted again? Yes, I do. But the point is, she probably never should have been given that chance, because the judge just should have got rid of the juror that should have been the challenge for cause was granted, but the prosecutor wouldn't take no for an answer. And the judge is like, well, the prosecution wants it. I better give it to him because, I want to get reelected in a couple of years. And so I better do this. And guess what? Now, at great expense to the taxpayers of El Paso County, they get to do it all over again. Letecia Stauch gets a clean slate, which means, now, like I said, I don't think she's probably going to prevail on her second trial, but you never know. I've won trials I should have lost. I've also been able to cut deals, right? What if witnesses aren't available? What if they realize, oh my gosh, that evidence was accidentally disposed of? We don't have it anymore. So, like I said, this is a big deal. I tell judges all the time, there's a couple of things that the judges can control, right? Who you get rid of, right? Why are we making this an issue, Judge? I've literally told judges, Judge, I've made my record. If you think this is the witness or the juror that you want to hang your hat on to see if this case comes back, I have made my record. Let's roll, right? And usually a good judge will say, you're right. We've got plenty of jurors. It's not like we're going to run out of jurors. Why create the record? And a smart DA will say, you're right, right? The other thing is when it comes down to jury instructions, the defense proposes a jury instruction, right? You just need a scintilla of evidence to get a jury instruction, right? A mere scintilla of evidence for that instruction to be given, like self-defense, is usually the biggest one you get there, right? Maybe like involuntary intoxication, voluntary intoxication, something along those lines, right? And so those are the things that you say, Judge, here it is. I'm submitting my instruction. And the judge is like, well, I don't think so. And the prosecutor will say, well, I don't think there's evidence. I don't think it should be given, Judge. And I literally tell the judges, Your Honor, you can give it to the jury and they can consider it and potentially reject it right now, right? And you're not going to get any trouble. You're not going to have any issues if you give it and the jury rejects our instruction. Or you can deny it. I will make an appellate issue out of it. And if the Court of Appeals believes that a mere scintilla of evidence was presented and I should have received that instruction, guess what? We're going to be back here in 3 years doing it all over again. Good judge will usually say, you're right. Is it really worth risking all that? And the prosecutors will always be like, oh, you can't do that. We tried a murder case and they big bitched the guy. We beat him on the big habitual. So you have 3 felony convictions. You get convicted every fourth. He was going to get 96 years on the F2 that we tried. We go to court. We try the case. I mean, I thought we won. The DA thought we won. And they come back not guilty to first-degree murder, guilty of second-degree murder, which, like, at that point, might as well found him guilty of first-degree murder, right? 96 years. 96 years he gets. But during the jury instruction conference, we requested some jury instructions on the type of injuries that should have, and the instructions that should have been given. The judge rejected it. Defense, what do you know? Well, Judge, we maybe looked at this a little closer than you have over the last 2 years since we've been waiting to try this thing. And we think we're entitled to this instruction. No, you're not. Guess what? Goes up 3 years later, it comes back, get to do it all over again. And in that particular case, we went from 96 years to 12. Okay. Now, I'm not going to say that's going to happen to Letecia Stauch's case, but stranger things have happened. And why did we go from 96 years to that? I'm not really sure, other than we just convinced them that they didn't want to try this case again. And, they weren't going to go on first-degree murder. We were only going to go on second-degree murder this time. So the moral of that story is you never know what's going to happen when you do it all over again. Now, a couple of other issues were addressed in the Letecia Stauch case. One of them was the search warrants in that particular case. But here's a good quote that I tabbed. This is from the Letecia Stauch regarding the peremptory challenges. Additionally, because they were trying to say, hey, the defense set this up. You can't invite or create error. Okay. And it says the Attorney General relies upon Justice Samor's dissent in Abu Nabatubay El, expressing that defense counsel's decision not to use a peremptory challenge to excuse a juror after the loss for a cause challenge is a classic example of waiver or invited error. And I know Justice Samor. I know Justice Samor when he was a young prosecutor in Denver. Then he became a district court judge, and now he's on the Supreme Court here in Colorado. And I actually saw him when we were at the Supreme Court in D.C. years ago, because he wrote the dissent in that particular case that went up to the Supreme Court, and they agreed with him and my people that we represented. Anyway, like Justice Samor, the Attorney General suggests that counsel may simply request and trial courts may encourage to grant an additional peremptory challenge. But in the Abu Nabu El case, the record here lacks any indication defense counsel was acting strategically, finding no invited error under the same circumstances. Additionally, we are not persuaded that defense counsel should be required to use a peremptory challenge to excuse a biased juror after the court erroneously denies a for-cause challenge. Moreover, nothing prevents the prosecution from using a peremptory challenge to remove a juror who should have been excused for cause. That goes back to protecting the record, right? Nor are we persuaded the defense counsel may re-level the playing field simply by requesting an additional peremptory challenge. Our Supreme Court has consistently recognized the type of error implicated here, a violation of the defendant's right to an unbiased jury, as so harmful that it warrants automatic reversal. Boom. There you go. Like I said, I've always said, you think there's an unjust result that takes place here? Only one person to blame. Here, prosecutor, 2, judge. Okay? They go on to reversal. But the search warrant, once again, search warrants, give me everything. They actually give the descriptions of what they were asking for. The investigative detective sought a search warrant for Stauch's cell phone for the following: data that may identify the owner, address books and calendars, audio and video clips related to the above described criminal activity, call history, call logs, and visual voicemails related to the above crime, photographs and associated metadata related to the above described criminal activity, text messages, SMS, multimedia messages, MMS, recorded messages, and subscriber information modules, SIM cards between the cell phone owner and the co-conspirator involved in the crime. They go on email, internet, global positioning, documents, and other text-based files related to the criminal activity, application and other programs, any and all computer software to include but not limited to operating systems, applications, utilities, and any and all data within the computer storage device or other processing. How is that not a general warrant, ladies and gentlemen? That is a general warrant through and through. That is a rummaging in violation of the Fourth Amendment. Don't worry. The Court of Appeal says on the retrial, don't have to worry about that. That is not a general warrant because there was enough specificity in the affidavit to, really clear all that up, right? Generally, on a search warrant, remember this, ladies and gentlemen, you have to know what you're looking for, and you have to know where it is, hence the reason for the search warrant to go in and get it. You don't get to go rummage. That's what the King's men did, right? We don't like you today, Mr. Reich. We think we're going to come into your house and look for something. Well, what are you looking for? I don't know, but we'll know it when we see it, the soldiers say. And from there, they come in and they rummage. And they're like, we knew it. You had something here. We didn't like you anyway. Arrest this man. Take him away. That's what the Fourth Amendment was prevented to do. But with the cell phone data, then everything they do, and this is the part that gets me. And we had a great hearing, and we've got a case. I swear to God, I think it's going to come back. I really, really do. Now, don't get me wrong. My client was convicted of being a bad, bad man and maybe got one of the highest sentences in the entire nation for human trafficking after a 4-week trial. For those of you who are with us, you may remember I was out for a month. 2 Mays ago, I think it was 2 years ago. Anyway, the appellate attorney, great, solid, says he's never seen a better job of preserving the issue as it relates to cell phone data. We had a hearing, right? We had a hearing. And I swear to God, this is what happens in every hearing. And maybe one of these days, somebody's actually going to get it, right? So you bring in the guy that dumps the cell phone, okay? And they act like it's such a big deal these days. Well, we hooked it up to the gray key and we cracked the code, and then we used the Celebrite to download it. And you say, all right, Mr. Download Man, let me ask you a couple of questions. Did you take a look at the search warrant when you got the phone? Yes, I did. And what did you do? Well, we confirmed that it was the same phone that was identified in the search warrant. Okay, and how'd you do that? Well, there's certain codes that, identifiers on the phone, etc. Okay, great. Now, what did you do to limit the scope of your search, Mr. Download Man, of the phone? And they literally say, and this guy's been doing this at this point, had done it like 20, 22 years. And what did he say? How many times? I asked, did you look at the date restrictions on the phone, on the warrant? I did. What did you do to do that? Nothing. What'd you do? Well, we downloaded the whole phone. Well, why would you do that? Well, there are no date restrictions, and we can't limit anything through that download by way of dates or descriptions of photos during this particular time period. So they dump it all in its entirety, and they'll tell you this. They're almost proud of it, and they say we have to dump the whole thing before we can look at it. It's like, you got to pass the bill before you can look at it to find out what's in it, right? Tell me how that is not a Fourth Amendment rummaging through the cell phone. It is. They dump the entire phone. They then give the phone to the detective and say, here, go look for what you're looking for. How is that different than the soldiers showing up and knocking on the door saying, we don't like you today. We're going to go through your house. We're not sure what we're looking for, but we'll know it when we see it. That's the exact same they do with the cell phones. But the courts have been giving everybody a pass on it. But frankly, I don't think anyone's done a good job at a hearing as we did. And of course, the judges at the district court, they just poo-poo it. Oh, Mr. Reich, there you go with your legal theory in the Constitution. Don't you know this isn't about the Constitution? This is about convicting your client who we think is guilty of doing bad things. And if we notice that, human trafficking is really bad, these days, and it gets a lot of publicity. So I'm not going to be the judge to throw out this cell phone search and maybe your client run free, right? So they deny the motion to suppress. Hopefully it goes up to the appellate courts. I've got a good feeling about it. I really do. I don't see how the courts can ignore it. At least the appellate courts. Appellate courts, they're a little brighter, usually a little sharper. They got the cold record, the facts right there, and they don't get to, have to deal with the present, the rushness of being in court. So anyway, they say, hey, close enough for government work. Keep the phone. Let's convict this lady. Do it right. Just give some, give her, at least make it look like you're giving her a fair trial by getting rid of, people that know people at the DA's office, for goodness sake. Right. Unbelievable. But at least the court kind of established and that's always been my thing. Like, judge, why is it my job? It's not my job to do the prosecutor's job. You're asking me to do the prosecutor's job, which is what the prosecution was even saying. Well, the defense counsel should have done the prosecution's job and the judge's job for him by exercising a peremptory challenge. We wouldn't even have this issue. Literally, that was their argument. Well, if the defense attorney had just used the peremptory challenge on the one that was for cause, then we wouldn't even have had this issue. It's the defense's fault. And the court says, no, judge, you should have read the freaking statute. And prosecutor, it's your freaking record. So there you go. You have to deal with the mess. And now they got to do it all over again. The question is, why will the DA's office let the same guy do it again? That case was such a slam dunk. There was no doubt in my mind that Letecia Stauch was going to get convicted. There's no doubt in my mind that she's going to get convicted again. But by God, can you at least just give her a fair trial? Like, just keep that, one juror off, and it would have been affirmed on appeal, and it was done. It was over. But no. Can they do that? No, because they're right. They're never wrong, and they're never going to concede it unless it comes back on appeal, and then they'll just ignore you in the hallways when you say, hey, when are we going to schedule that hearing? Now, remember, the attorney general who does all the appeals for the prosecution in this particular case can do a couple of things. One, file for a reconsideration of the entire Court of Appeals bench, which will be denied. They can also file for a petition for certiorari to the Colorado Supreme Court, which will more than likely be denied unless the Supreme Court was so appalled by this and says, that's not the rule that we had. I mean, no, they have that rule. I mean, the prosecution was relying upon the dissent in another case for their position. Hey, we've all been there, right? We've all been. Who hasn't had to rely on a dissent every now and then and say, well, I think with the dissent is much more logical. But anyway, then a mandate, what it's called a mandate, will issue, and she has to be retried within 180 days of the date of that mandate, which means she'll be taken out of the Department of Corrections. She's just down the street here, not far from the Colorado Command Center here for Crime Talk, and just off of Smith Road at the Colorado Corrections Women's Facility over here. And she'll be going back to the El Paso County Jail, awaiting trial. And guess what? She's still entitled to bond because that would have been the time that it happened. Now, don't get me wrong. She's not going to get a bond. She's not getting out. But, who knows? Maybe she had met some wealthy guy online or, dating from the jail that wants to help her out and do that. I mean, you never know. So, seen stranger things that have happened. All right, so that's the Letecia Stauch. Were there any questions about Letecia Stauch that we need to take there? If not, we'll move on to the Tanner Horner trial. All right, so Tanner Horner, this was the FedEx driver that was delivering a Barbie doll to the house of Athena Strand in Paradise, Texas. And this is back in 2022. Okay, here we are. Took 4 years to get the trial. And then Tanner, he's facing murder charges. They're looking at doing the death penalty. Why? Because, well, it's Texas, right? Although I was just in Texas, and the lovely Miss Kristen hates this joke, but we got off the airplane and I stepped out there and I said, "You smell that? It's the smell of freedom." That's what I smelled. That's right. Anyway, she doesn't think it's funny. And then when we were driving into Dallas from the airport, there's this car dealership. I've never seen it. Like 8 flags, American flags and Texas flags on each side. I've never seen these flags so big in my life. They're everywhere down there. They love Texas and they love America down there. I wish I could say the same thing in Colorado. I don't think you ever see an American flag flying. And I just got a big one. I just got to find a place to put it. I got to get it mounted. I was thinking maybe a pole in the front yard with a maybe light going up on it so I can keep it up 24/7. Anyway, we digress. All right. So this Tanner Horner guy takes 4 years now to get him to trial. Morning of trial, they seat the freaking jury. And what does he say? "I'd like to plead guilty." Yep, that's right. Pled guilty to the murder of Athena Strand. And so now the jury got to see him plead guilty because they can take that into consideration for the penalty phase, because now they're going to decide whether he gets the death penalty or life without parole. So what do we know about this? So this guy, Tanner Horner, FedEx delivery guy, delivering a little Barbie doll to this house. What we do know is when he gets arrested, he's like, "Oh, I panicked. I thought I hit the girl. I told her, to be careful or something. I moved and I panicked. So I put her in the FedEx truck." Right now, they ultimately found her little 7-year-old body, in like a little river or a little pond. But here's the thing, Frank, if you can put up the picture. He said that she was basically unconscious, that he must have hurt her while she was, got hit by the car, by the FedEx truck. And he says that she was basically unconscious. Well, as you can see from this picture, guess what? From the video in the van, she was not unconscious. She was awake. Now, what the prosecutor said, and this is, I gotta save this. So the FedEx driver who's accused of abducting and strangling the 7-year-old girl he put his face in his hand as a photo is displayed of him driving her to her death. Oh, Exhibit A, right? They have a picture there of 7-year-old Athena Strand standing behind Tanner in the FedEx truck. Athena was allegedly snatched by Horner when he was delivering a Barbie doll to her residence in Paradise, Texas. Horner initially claimed he accidentally hit the girl with the truck before panicking and pulling her into the truck. He said he then strangled her in the vehicle and dumped her body 7 miles from home. The photo, however, shows that Athena was alert in the trunk and did not appear to have been struck by the truck at all. Now, the district attorney says the jury will see footage on the day of the killing depicting the moments Athena was strangled to death. And the DA says somebody covered up the camera because they don't want you to see. Well, guess what? The prosecutor says the audio is still running and you're going to hear it. You're going to hear what a 250-pound man can do to a 67-pound child. And when I say it's horrible, I mean it. The DA says, I've been doing this for 25 years, and I promise you, buckle up. Like I said, Horner qualifies for the death penalty. He knows it's bad. He knows it's bad. That's why he pled guilty. And he was trying to get a little hope and little mitigation there. But when you see somebody strangled to death, ladies and gentlemen, or here in this case, you're going to hear her strangled to death, you'll be able to tell what the jury's going to be able to do. My guess is there'll be some people that are crying, They're just in complete shock. They'll be staring down Mr. Horner while in court. And that'll be the defining moment of whether he gets death or life without the possibility of parole. And remember, I mean, strangulation is the epitome of after deliberation. You don't just strangle somebody for a few seconds and they die. For them to really be out, we're talking 5, 6, maybe even 10 minutes for them to truly be dead. And then to take her little body, little 67 pounds, I think my dog weighs that much, for goodness sakes, and throws her in a pond. Dispose of her like garbage. And then this guy comes in there asking for mercy, saying, don't do the same to me, what I did to a little 7-year-old who just wanted her Barbie. It's going to be an interesting next couple of weeks. Now, of course, the defense is going to say, hey, he had a terrible childhood. He's got mental health issues, blah, 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 right? And I get it. If he was my client, I'd be throwing all that stuff out there as well. But as a defense attorney, you always have to think about, well, what's the other side thinking? How's this really going to play out, right? I don't know about you, but I've known lots of people that had crappy childhoods. And guess what? They never killed little 7-year-old girls. Not an excuse, right? At least not to most people in the world. Not an excuse. What do they say? The DNA creates the person, the personality, or DNA puts the gun in the hand. The personality pulls the slide back, and their character is the one that pulls the trigger. I think that's the way that saying goes. Not looking good for this gentleman. And like I said, if he was my client, I would be doing everything I could for him, but he's not. So we get to look at it truly objectively and say, oof, unless there's somebody on there. This is Texas, man. They don't play down there. You go around killing 7-year-old girls. Ooh. And yeah, we're going to have to see how that goes. We'll watch that. Frank, is that one we can stream? I can't recall. We'll see if we can stream that since it just started. If we can. Because the other one just finished up, right? The guy down in Florida that killed the lady from the party. Another simple rule. Little plug there for Crime Talk Search. Who's delivering your packages? Who's hanging out with your kids? Who'd you meet at that party that night? Do you really trust him? Big one tomorrow. All right. Gilgo Beach murderer supposed to enter a plea. Rex Heuermann. Remember the guy who said him absolutely didn't do it? I mean, sure, they got the genetic genealogy, right? And there was, like maybe his wife's hair in the stuff, but don't worry. The wife kind of says, I'm out. I'm divorcing him. I don't know who this man is. But she came back into the picture, was going to withhold judgment when she got the $1 million contract payment for the documentary. So one of the sons of a Gilgo Beach victim is suing Rex Heuermann and his family because they collected $1 million for the documentary. And the guy's name is Benjamin Torres, was 6 when his mother vanished in 2000. And like I said, Heuermann is expected to plead guilty tomorrow, which is a little surprising to me. A little surprising to me indeed, because they don't have the death penalty where he is right now. You think you're going to get out of prison, Mr. Heuermann? No, you're not. You're going to die in prison. You might as well try to make the government, crawl over glass to prove their case, and then, spend the next 25 years doing appeals, probably whereupon you'll die in custody, and, there you go. I'm not sure what the benefit of the bargain is for him other than avoiding a trial. Probably some weird stuff. The guy was, what was he doing? Killing like sex workers, allegedly. And, so Clearly the guy had some kinky things going on. So I bet they found a bunch. I mean, we already know, allegedly, that like he had a diary. He had like a checklist of before he was going out on killing people, how he was going to do it, how he was going to dispose of it, how he wasn't going to get caught, how he wasn't going to collect any evidence on him. A little checklist for murder. Guess he should have incinerated his pizza box at work. So yeah, that's not tough day for Mr. Heuermann tomorrow too. I'm not sure what time that'll take place either. I don't know if that's something we can stream or not, but that would be interesting to see for a man who professed his innocence from the day. And what did I say? Right? The defense attorney got up there and said, this is a travesty of a mockery of a sham. My client is innocent. We intend to fight this all the way. Blah, 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 blah. When you start making statements like that, you better be pretty darn certain that your client is 100% innocent. Maybe he's got a lock solid alibi before you start doing that. I get it. You can say, obviously, we're going to try this in a courtroom, not in the court of public opinion. And my client is given the presumption of innocence, and you all should give them that too under the Constitution of the United States. Thank you. Right? But when you start professing that your client is absolutely innocent, completely, totally wrongfully accused, you better be able to back it up. Otherwise, you're going to look like a horse's arse, if you know what I mean. Seriously. There you go. Let's see here. Frank, were there some questions or something that were highlighted? Because we don't ask for super chats, but they certainly do help when they let's see here. Jenny, member for a month. Laura, lawyer. Hit that yellow button. Crime Curious, new member. Kelly Dragonborn, new member. Sleuth Hustler, gifted one Crime Talk membership as well. So that's a good one there. Thank you all. Like I said, we don't beg for super chats, but we certainly appreciate them. And, you know, in the sense that it shows up on our screen here, highlighted, so it's easier to see the question. Let me go back here and see if there's some questions on here. And also, we got a couple minutes left. If you want to call in, we can give you that number as well. I should remember that. I should know that off the top of my head. 725-228-TALK, 725-8255. Only one rule. You can't listen through your computer. You can only talk on the phone. Otherwise, you know, there's a delay and it's a very awkward conversation. So if there's something you'd like to talk about tonight, whether, you know, the Letecia Stauch, the Heuermann case, the case down in Texas, we'll take your questions. There you go. That's right. Don't commit dating malpractice, ladies and gentlemen. For a small fee, you can find out who is going there. Who are you dating? Absolutely. Just saying, ladies and gentlemen. Scott, are you going to be covering it? Well, everything we talked about tonight we'll definitely be covering for sure. But I'm not exactly sure which one. Let's see. Uncivil law can win it. Let's see here. Uncivil law. It's been a while since we've talked, my friend. Like Alec Baldwin got a fair trial and walked away with murder. Now, Alec Baldwin got lucky. And I think that judge was looking for any way to make Alec Baldwin's case go away. You know, was there some bad faith on top of it? I don't think so. But it all worked out. And it was just one of those moments in court where the defense was like, I think we're winning. We're just going to stop now. Prosecutor kept arguing. Now, then it looked like the prosecutor was doing something shady, and I really don't think they were. But hey, it worked out for Alec Baldwin. Good for him. One thing I'm pretty darn sure of, Alec Baldwin will be checking any firearm he ever touches in the future to make sure it is not loaded, and probably pretty certain he will check it to make sure that he's not firing it anyone's direction. You know, those simple rules of gun safety. Can you add a virtue signaling emoji? This case is nuts. Human trafficking is bad. Yes, it is uncivil law. Like I said, I think at the time it was like 570 years my client got. They filed habitual accounts. The judge, who I frankly like, good person, known her for a long time when she was a prosecutor as well, stacked and racked him up. Usually they run those counts concurrent. Oh, no. She ran them all consecutive. So, distinct honor, because the DAs were very proud of it. I think it was on the evening news when it happened that my client, they were so proud of the highest human trafficking sentence in the United States. I think it has since been surpassed. Thank God. We didn't want to hold that record forever, but I still think it's coming back on appeal. I saw actually the victim advocate in court the other day. We got another case coming up, anyway, we were chatting and she was there and I said, yeah, that case is coming back soon. She was like, no, it's not. I'm like, yes, it is. It's coming back. We'll see. Could she receive the death penalty if found guilty? No. Colorado has repealed the death penalty, which, if it had been by referendum by the citizens of the state of Colorado, kind of like in California, right? Remember years ago, the California legislature repealed the death penalty. Then it went to the vote of the people and they said, oh no, we're keeping that. And then the governor comes in like, well, we're not going to use it. And we're going to do it. Now, don't get me wrong. There are arguments on both sides of the death penalty, but the biggest argument I think for it is if you have it, it is a tool for negotiation by the prosecutors, right? Because you'd be surprised. Some of these guys go around killing people. They are really tough guys until they're not. And then they just turn into a little bitch and, oh, I don't want to die. And so they'll say, fine, I'll plead guilty to it. It's a huge, negotiation tool for the prosecution. All right, we got a call. Who do we got, Frank? Uncivil law.
How are you doing?
How you doing, my friend? It's been a while.
I'm doing pretty great. I thought we talked about this juror thing in the Letecia Stauch case.
Yes.
Because what blows my mind is this is straight statute.
I know.
And the judge had the statute, and he had the weekend.
And so did the prosecutor.
And so I don't understand, one, why the prosecutor wasn't also just throwing a flag, because surely he can read the statute as well as anyone else.
I know.
And how the judge was able to somehow read the statute and come to some other conclusion other than what it plainly says. So if someone can explain that to me, that'd be great.
Well, I mean, I got the opinion right here. And that's pretty much what the Court of Appeals said is like, what are you guys, stupid? The statute says this. And, you got somebody on the jury that their son-in-law works at the DA's office as a prosecutor in the same office. I think everyone thought, well, he's an alternate. He'll never get on the panel. And then somebody got sick. And so they moved the alternate up and they deliberated. Had he not deliberated, had this juror not deliberated, it would not have been an issue at all. But since he did, it was. And like I said, I don't know what the judge was thinking, because the statute clearly states you can't have this person this close to somebody prosecuting the case on the jury panel. And jurors who fall within one of these categories are considered biased as a matter of law, impliedly biased under Section 1B and actually biased under Section 1J, unless they can be rehabilitated. Upon a challenge for cause, the court is required to excuse them because, except as described in subsection 1J, they cannot be rehabilitated. And then they said in McCrander, the Supreme Court held that when an elected district attorney is the attorney of record, section 1610-103-1B includes prospective jurors who are related not only to the elected district attorney, but also to any deputy district attorney in that office at the time the jury selection occurs. That's the Novotny case. So it says the statute directs automatic removal of a jury related within the third degree to any deputy district attorney in the elected district attorney's office of the elected district attorney's of records office, regardless of whether the deputy district attorney appeared or participated in that case. The beautiful thing about the law is most of the stuff has actually taken place. And this time it's taken place numerous times, and the judge still couldn't get it right. And neither should the prosecutor. And as I said earlier, when I was a prosecutor, they told you it's your job to protect the record. No matter how much you want to do it, you got to protect the record because you are going to be the one that has to protect it on appeal. Why would they do that? I have no idea. What are your thoughts?
No, I don't understand this. This is my point. The statute seems clear on its face. I'm not sure whether or not the statute is a good idea in the first place. I mean, that's a policy question, but it is what it is. So just read the statute, put the fries in the bag, as we say.
Yeah. Why create issues? But this is my experience all the time. Prosecutors want to be right. Oh, judge, we really like this juror. It's no big deal. Don't worry about it. Judge's like, well, they gave all the right answers. They said they could be fair and impartial. And even though I'm related to somebody in the district attorney's office, that's not going to affect my ability to be fair and impartial in any way. Well, guess what? The statute says it will. So you don't get a say in the matter at this point anymore.
Yeah. Also on this Letecia Stauch thing, do you happen to know off the top of your head whether or not she was charged originally with the death penalty?
I do believe she was not charged with the death penalty. The case goes back to 2019. And so our good governor has been in office now going on his 8th year. And they repealed that his first time into office. So I believe
but they repealed it effective as of July 1st, 2020. And that's why I asked, because I believe she was charged before then. So I don't know whether or not technically they could go back and, change their mind, because the charge date would be before the change in law. Not that they would, but
I don't think they would, and I don't think that they could at this point. You're stuck with the case of the law.
Yeah, if they didn't
and
charge
it goes
her in
back
the first place with the death penalty, then I think you're right.
Yeah, so I don't think they get it. Literally 10 years ago, El Paso County, they would sentence to death on something like this. The demographics down there have changed a little bit, but your first murder, it's tough to get. I don't think they had enough aggravators, so to speak, to get the death penalty on something like this. You got somebody
first murder, you get a bye. It's that second or third murder where we really get concerned.
Well, that's kind of true. Yeah. I hate to say it, but it's not bad. Yeah. Leave it at that. So
the FedEx thing sounds horrific. So I think that's a death penalty case for sure.
Yeah, I think what it's going to come down to is the guy forgot to turn the volume off on the camera. So they're going to hear this little 7-year-old girl fighting for her life and having literally the air sucked out of her. And my guess is the jury will make up their mind at that point, whether it's death or life without parole at that very moment. And everything else will simply be perfunctory at that point. Because some people...
Did you happen to listen to the Supreme Court oral arguments on the birthright citizenship case?
I did.
What'd you think?
I think it was interesting. They're not asking for a retroactive, but they want something prospective, that if they do that, it would only affect the rulings from here on out. I think the justices telegraphed that I don't think they're going to go along with it. And the Wong Kim case, was it Wong something Kim case?
Wong Kim Ark.
Wong Kim Ark from what, 1897 or something like that. You know, I think they're going to not reverse it, but I think it was, for the most part, good argument by both sides. But I think the justices were telegraphing where they were going. Although I think most people would say, I mean, I think if you focus on the actual, you know, subject to the jurisdiction thereof and what it meant at that particular time, I think that the executive order has better chance of going. But I think the Supreme Court's going to look at, well, how is this really going to affect everything else these days? So I don't know, because, you know, I
think the biggest problem for the government was that he just wasn't prepared to fully answer like how this would work. For example, they asked, what about Native Americans? Because Native Americans aren't considered birthright citizens under the 14th Amendment. They weren't given citizenship until an act of Congress in the 1920s.
Yeah, which Congress can do, right?
His theory, yeah, sure. But under his theory, the question would be, well, was that decision wrong? Are Native Americans, in fact, birthright citizens under the 14th Amendment? And he didn't know the answer. He's like, oh, I have to think about it. What do you mean you have to think about it? You don't know the answer? You haven't thought this through all the way? I mean, you're the one who wants to change the interpretation of the 14th Amendment, and you haven't thought through, geez, what does this mean for Native Americans?
Yeah.
That struck me as really sloppy. And then it was just this like Kavanaugh or something asked him, what about Section 5 of the 14th Amendment? Well, golly geez, this is the first time anyone's asked me. Really?
Yeah.
Section 5 of the very amendment you want to interpret and you haven't thought about before? This is some weak sauce, Scott.
Yeah. No, I agree. And I think their argument was, well, it doesn't really matter because it's only prospective is going forward from here. But the justices kept saying, but, you know, we're textual people. So we need to know what was the, you know, what did things mean, you know, back in 1865 when they were passing the 14th Amendment. I get it. I think the government loses on this one.
Well, even on a going forward basis, I'd like to know if the Native Americans are birthright citizens under the 14th Amendment or not. That'd be swell.
Well, I think the Solicitor General, had he been intellectually honest, would have said no.
Yeah, well, maybe he should have said no. But either way, he has to think it through, and he has to know the answer to these questions.
I agree.
He has a coherent theory and thought it all the way through. And he's like, well, I don't know. That's like, oh, you haven't thought about this? When you want to change what a birthright citizen is, you haven't thought about whether or not that changes for Native Americans one way or the other? Are they in or out? You don't know? This is sloppy. Yeah.
Well, I think his argument should have been no under the 14th Amendment, hence the reason why Congress gave them citizenship years down the road via legislation. I think that's what he should have said. Like I said, if he was going to be honest in his argument, but I think he was trying to split hairs and come across as, you know, politically correct.
You bought the bullet, which I thought was interesting because they asked the ACLU person the same question.
Yeah.
And the ACLU person actually said, no, I don't think that Native Americans are birthright citizens. She bought the bullet.
Yep.
And I'm like, okay. I mean, at least she thought it through.
I mean,
that's
her answer,
but she thought it through.
That's the answer. If you go back and look at the history at that time, one of the reasons why they put in the language subject to the jurisdiction thereof is, you know, they were still fighting the Indians, and they didn't know if they wanted them to be citizens. So yeah, I mean, that was the correct intellectually honest response was no. And guess what? But Congress fixed it down the road. So I think the government loses on that one. I don't think they're going to get the executive order approved. But no, who knows? Maybe there's some bargaining going back, on behind the scenes. But I just don't see Roberts going along.
All I have to say is, if I was arguing for the government, I would have thought about these questions because they seem pretty basic. I'm not sure what my answer would have been, but I would have thought about it and had an answer. So, we just fired the AG. If they need a new SG, I'm available.
Well, I think the president got up and walked out when he heard some of those answers because I don't think he was impressed by these.
I'm available, Scott. I promise I'll have answers to these and other exciting questions.
I know. But, and I don't know what the Solicitor General makes, but I'm sure it's still pretty good even with the government job. But that guy's going to get out, leave the government and go make $1 million a year minimum arguing cases before the Supreme Court. So you would think, and I've heard him argue before, and usually he's pretty good. But this one, it seemed like he was kind of phoning it in, so to speak.
Yeah. Also, I don't have that voice thing that he has and RFK has, so I have better oratory.
Well, there you go. Yeah, it's an acquired sound for sure that he does.
I'll let you go. It's been nice talking to you.
Good talking to you. We got to get together soon. Maybe we can do something together. All right.
Yep. You know where to find me. Talk to you later.
All right. Talk to you. Bye. All right, ladies and gentlemen. Wow. Can you look at that? Already an hour has gone by. We only do an hour. Keep you coming back for more. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. We'll see you tomorrow. We'll put up a show every day, unless, of course, I'm in trial, which I'm going to be for 10 days coming in a couple of weeks. No, 2 weeks. Anyway, remember, the Constitution matters.